Not all judges are meant for complex cases. Ultimately, all major bankruptcies are essentially financial operations. They may well have all kinds of levels of creditors. You've got to be able to deal with the finances of the bankruptcy to have a successful bankruptcy. I tried to work on getting all sides to a case, and sometimes there are 2 sides, sometimes there are 50 sides, and moving all of the parties towards a solution that will work and that everyone would buy into. I don't know that I ever signed a confirmation order that paid 100 cents on the dollar and interest to all of the creditors. To me, it's the best use of the bankruptcy code that I could imagine. You need to know the judge, you need to know all of the rules, and you need to follow those.
They call him the rock and roll judge, a man who could go from a courtroom to a concert stage without missing a beat. He's run marathons, played tuba, directed Broadway musicals, and reshaped the very idea of how bankruptcy law is practiced in America. From the billion-dollar Osaka reorganization, one of the most successful in history, to the small businesses that needed a fair shot, Judge Richard Schmidt was known for one thing above all else: a deep respect for people and a courtroom that ran like a symphony. Today, the retired Chief Judge of the Southern District of Texas joins Reviving Giants to talk about the evolution of Chapter 11, the human side of financial collapse, and the rock and roll spirit behind the bench. Well, we're very pleased here on Reviving Giants to have former Chief Judge of the Southern District of Texas, Judge Richard Schmidt. Judge, thank you for being on the program today, and I'm looking forward to our conversation about your time on the bench, the cases that you've been involved in, and especially your view of Chapter 11 today. So again, welcome.
Thank you. It's good to be here. I was appointed in 1987 to Corpus Christi Division. First time there had a bankruptcy judge in Corpus Christi. And I served 2 terms of 14 years. So I got off the bench in about 2001.
I didn't realize that you were the first bankruptcy judge in Corpus. I missed that fact.
Right. There were only judges in Houston prior. There were 3 judges in Houston prior to my appointment, and they appointed 2 new judges in Houston and 1 judge in the southern part of the Southern District, Corpus Christi. And I had the Laredo Division, the McAllen Division, the Brownsville Division, and the Victoria Division, as well as the Corpus Christi Division. So I was doing a whole lot of miles on my car back in those days.
I can only imagine. Judge, you've been called a Renaissance man, musician, athlete, and judge. How do all those sides of you fit together?
Well, prior to being a judge, I was pretty much involved in all of that beforehand. I had directed a number of musical theater presentations. I had starred in some of them, and I had also been president of the symphony and president of the opera in Shreveport, where I was practicing law at the time. And so all of that just came naturally to me. And when I became a judge, I think it made more sense, because you couldn't, when you were coming to a place where you don't really know anyone. I was not from Corpus. I was living in Shreveport when I was appointed in Corpus. And so I really knew no one. And I think the public is entitled to know their judge. So to the extent that you can be involved in other things that are not judging, then you get to know a lot of the community. And I think that served me well.
Well, I think so too. As we have one thing in common among many, is that I'm an old actor as well. I was a big kid, so I always got to play Santa Claus in the school plays, but rolled that into theater, and then worked on a couple of movies. But what's interesting about that is I find that through that process, you have great confidence in public speaking, in presenting yourself, and I suspect that helped you on the bench.
That is true. I think my favorite role was Henry Higgins in My Fair Lady in Shreveport. And interestingly enough, my band was playing for a charitable event last week, and a lady came up and just had to tell me that she had seen me in My Fair Lady, which was maybe 20 years ago. So, I mean, it's been quite some time ago.
Let me ask you this. After you had a very successful career in the Air Force and the JAG Corps, retiring as a full colonel with many commendations and honors. What pulled you into bankruptcy law? And then later on from that practice took you to the bench?
I was very fortunate to be in the Air Force, and I served 4 years on active duty and then decided to stay in the reserves after that. And I was a JAG officer at first, but when I became a judge, there was some confusion as to whether or not you could be a JAG officer and a judge. And so I just decided to join the line. My general wanted me to be a squadron commander anyway, so I thought that'd be a good way to deal with it. So I got out of the JAG Corps, became a line officer, and I was a squadron commander. And then later I became the group commander, which was about a 1,000-member unit that I was in charge of. But so I really was a generalist lawyer, just in Shreveport, Louisiana. That's a smaller town, kind of like Corpus, and many people there. I mean, there were not real specialists. There were people who did trial work, perhaps, but there wasn't really a bankruptcy specialist in the town that I was aware of. But I did, when there was a bankruptcy to handle in our firm, I would take care of it. And I would also, when there was trial work to be done in our firm, I would take care of that also. But in any event, that's what got me aware of bankruptcy. Then the bankruptcy judge in Shreveport decided to retire, and sort of as a last minute thing, I thought, well, why don't I just apply for that? So I waited way too late to apply, but I waited and I applied and I didn't get it. But there was one open in Corpus Christi, and they were having a hard time finding someone because they thought you needed someone from a smaller town, not someone from Houston. It wouldn't be helpful. They would not be happy there. And so I got a call from Henry Politz. Henry Politz was a Court of Appeals judge, Fifth Circuit Court of Appeals judge, and he had practiced law in Shreveport. He was an excellent trial lawyer, and a big, heavy-set guy with a Cajun accent. And he would tell Cajun jokes, and they were just absolutely hilarious. But in any event, he had called me because they were having trouble finding someone for Corpus, and he was wondering. He said, "Well, you're licensed in Texas, aren't you?" And I said, "Well, yes, I am. I went to the University of Texas, got my degree there, got the bar, and I decided to take the Louisiana bar while I was a JAG officer at Barksdale Air Force Base, and did that too. So I was licensed in both states." He said, "Well, you have any interest in going to Corpus?" And I said, "Well, yeah, I guess I would try that." And sure enough, I got appointed in Corpus and moved down there, and that's what started the Corpus Court and the South Texas courts, for that matter.
Wow. Well, you and I have another thing in common. We're both Longhorn fans now. I didn't attend Texas. My oldest brother did, and I've been rooting for the Horns since I was about 5. And I haven't seen it, Judge, but I've heard rumors that there were either burnt orange or perhaps red robes, depending on who won, the Red River rivalry. Is that true?
Well, I had a law clerk from the University of Oklahoma, a lawyer, and before she was my law clerk, she would appear in the court after the rivalry, and she would either wear her red robe because they won, or I would be wearing an orange robe because we won. Luckily, I actually wore the orange robe more often than she wore the red one. Uh, I mean, Texas is a great school, and it's a great program there, so I enjoy it.
I can only imagine it was a lot of fun a weekend ago. So you joined the bench long before, there was a complex case uh, system. What's changed the most, in your opinion, in Chapter 11 since then?
Well, you need a complex system, first of all. I mean, you it's very difficult for a complex case to be handled in just a court that just handles it like any other case. Complex cases involve way more hearings. They have to have the opportunity to get there quickly. There are a lot of decisions that got to be made right in a hurry, and then they need a judge that can handle a complex case. I mean, not all judges are meant for complex cases, and so I started developing a system for complex cases. I remember the first case that got filed in my court was Greyhound, which was certainly a complex case. And I needed to be able to handle all those cases as quickly as possible and to make decisions as quickly as possible, but obviously the right decision. And so I I I appointed a committee of lawyers, primarily Houston lawyers, by the way, that because they had more experience with those kind of cases, and we developed a complex system. And basically, it was a system that allowed lawyers to have a hearing quickly and to get to a hearing quickly, uh, and uh, uh, and it was a user-friendly court. It was not, I before COVID, I had lawyers appear by telephone lots of times. I mean, we did that. We did hearings as best we could because we would have a lot of lawyers from Houston. I mean, and from New York, for instance, in cases. So we had to have a way to be able to handle all of that and to be able to make certain that you were doing the right thing and that you were providing an equitable court for people to practice in.
I'm curious, with your military background, when you were working with the lawyers in Houston, did that help you structure, the your
I doubt that any of the
office and
lawyers
chambers and the court?
I doubt that any of the lawyers that handled those cases back in those days knew that I had that military background. However, there were weekends when I had to, because the military, if you're in the reserves, you appear on a weekend. So I would go up to Shreveport for the weekend, uh, but and and sometimes because I was in the military reserves, we might be in Germany for 2 weeks, and there might be hearings that need to be had. I don't know whether a bankruptcy judge can hear a hearing in Germany while they're on military, but I did, and those we carried on to do that. And however, I guess if they look very closely at my lapel, they would see a Legion of Merit, which would probably indicate to those who knew anything about the military that I'd probably been a colonel in the Air Force. But in any event, uh, I think it was good practice because, first of all, the military requires that you be able to handle 1,000 people and all of the things that come up, and there are inspections and there are all sorts of things that happen all the time, and
Right.
and so if you're going to do well in the military, you've got to be able to handle all the people and all of the issues that come up, and so it gave me good experience for not only as a judge, but it's given me great experiences for running companies now. When I after bankruptcy as a judge, I when I have a case where I end up having to run it, either as a CRO, as a trustee, or something of that sort, or a receiver, I have a lot of experience doing that, and so it helps me maneuver in that respect.
No, I can understand that. You know, a lot of bankruptcies these days are focusing on the balance sheet, liability management exercises. We've seen a lot of Chapter 22. Spirit Airlines, is a classic example. They spent, I think, $33 million in professional fees. They got out of bankruptcy. 5 months later, they go back in and they now decide, oh, we're going to fix the operating business. Do you think that there's been a shift from actually trying to fix the operating business in Chapter 11 to just trying to fix a balance sheet? And is that a good thing or a bad thing in your opinion?
Well, okay, ultimately, all major bankruptcies are essentially financial operations. I mean,
Right.
they may well have all kinds of levels of creditors, banks, and various mezzanine lenders, et cetera. They're all a function of money and numbers and all of those things. So you've got to be able to deal with the finances of the bankruptcy uh, uh, to have a successful bankruptcy. On the other hand, I don't think that just balancing the balance sheet is necessarily a good way to deal with it. There needs to be a plan that successfully reorganizes, needs to understand what the problems were with the plan or with the operation beforehand, and successfully operates it. Or if it can't be done, perhaps it needs to be sold. But in any event, the fundamental problems with the organization have got to be solved if the bankruptcy is going to be successful.
Do you think in today's world that Chapter 11 has evolved so it's just for the biggest bankruptcies and not so effective for middle market organizations because of the high cost and timing?
Yeah, there is no question that a bankruptcy, if handled the way the code provides for, requires a whole lot of work and a whole lot of legal work. I've got a case right now involving several grain elevators in the valley, and the amount of legal work that's required. I mean, every time there is any kind of a motion or anything of that sort, the lawyers have got to be involved in there, and they got to be prepared, and they've got to handle the whatever the rules are, the judge's rules for providing whatever notice that there is for hearings that are about to happen. So there is a whole lot of money involved in a bankruptcy, and there are lawyers who are able to handle them fairly inexpensively, but I don't, we talked a little bit about Chapter 5. There's no question that a system for smaller cases and probably larger than Chapter 5 needs to be there so that people can handle the cases a little more efficiently and move them forward and cost less. I mean, the amount of fees are huge, and in a big case, I mean, they can afford it. But all of the work that is done in a big case is also done in smaller cases, and so the lawyers have got to find a way to do that and do it in a way that doesn't charge a lot of fees.
Yeah, well, I've often said more than once, to whether it's to clients or just in conversation, it costs a lot of money to go broke.
Right, right.
You've
I've
been,
pretty much during my time on the bench, I tried to work on getting all sides to a case, and sometimes there are two sides, sometimes there are 50 sides, but trying to get all sides of the case, thinking in terms of what's going to be best for everybody in the case, and moving all of the parties towards a solution that will work and that everyone would buy into. I think probably uh, the vast majority of my cases were solved in that way. I mean, so I sort of mediated the cases as a judge, the judge handling it. And there were cases that I even gave uh, gave them my thoughts as to how it could be handled. Once you know enough about the case, it might well be that you can make suggestion, and then they think, oh yeah, well, okay, let's go that way. So I was very successful in getting the parties to agreement with respect to plans. So
Well, it's interesting you say that, because one of my original mentors, Harry Perrin, who's a retired notable lawyer here in Houston, told me when I started in this business in the 80s. He said, "Listen, you can argue and you can fight hard, but if you're not willing to compromise at some level, you're never going to get anything done."
right. And Harry was a good lawyer. There's no question. Harry appeared in my court many times, and he was one of the best.
Judge, Asarco, one of the largest bankruptcies ever, has been called the most successful in U.S. history. It reorganized, it paid its creditors. What made it work?
Well, the first of all, it wasn't required to be done in 6 months. Back in those days, the bankruptcy code was not envisioned to handle complex cases like that in a period of 6 months. You weren't supposed to get in and get out, in other words. So maybe that was part of the reason that it was successful. Now, that's not to say that speed is a bad thing in a bankruptcy. I mean, if in fact you can get to a resolution in 6 months and get a plan and get it applied and get it out of there, I mean, that really is a good thing to have happen. I'm not saying, but the law has changed to where we now expect that a bankruptcy you'll be in and out, and maybe the you'd like to do it in 6 months, maybe it'll last a year, but Asarco, I think, took 6 years. And it went through a number of iterations. The very first plan that they came up with was a plan where they were going to sell it, and there was a company out of out of of, uh, uh, of India that had plenty of money and wanted to buy it, and they made an offer, and that was the offer that was accepted, and they were going to go forward with a plan that they had to pay a certain amount for the case.
Mm-hmm.
About that time, there was a huge financial crisis in the world, and I think maybe the value of the dollar went down. I don't know whether the value of the dollar went down, but they came into court and said that they were going to anticipatory repudiate the contract.
Wow.
I had no idea why they were going to do that, because the odds that a contract would be actually consummated in a bankruptcy, there are a lot of ways where you could throw up problems. But anyway, they did, and the contract was not consummated. And so the lawyers went back to work, and over a period of time, the price of copper went up. And so as a result, the plan then made imminent sense to reorganize. And the owner of the company, Grupo Mexico, decided it was going to propose a plan, and the debtor decided it was going to propose a plan, and there was a large asbestos liability in the case, and the lawyer Sandy Escherman, who's another one of the great lawyers who's appeared in bankruptcy courts, he worked out a deal with the Grupo Mexico whereby they would pay for that claim. And I think it was maybe $1 billion that they were going to pay for it. And basically, when they did that, that meant that the debtor, if he wanted its plan to work, he was going to have to do the same deal with him. So Sandy, certainly his client, came out smelling like a rose, but ultimately the Grupo Mexico plan was confirmed because it was identical to the debtor plan, but the debtor plan did not take care of, it paid 100 cents on the dollar plus interest to all of the creditors, but it didn't pay a dime to the equity. And equity does have, I mean, they are in fact a part of the case.
Yeah.
And so if you're paying 100 cents on the dollar to everybody and not paying a dime to equity, and so equity had a plan which they kept. They paid all of that too. They paid 100 cents on the dollar to everyone, but they kept the equity on the case. So they were confirmed as the that was the plan that was confirmed, and then that left open. Of course, that there were huge issues in that case. The for instance, there was a lawsuit against the equity because they had, over the objection of counsel, they had pre-bankruptcy sold the a mine in South America that was the crown jewel of Asarco, and so we had a fraudulent conveyance lawsuit that had to be handled in that particular case because it was a whole lot of money involved, and because there was the company was from Mexico. I thought, rather than having an issue over a bankruptcy judge deciding this, what about let's have a district judge decide it? And Andy Haynen, who's in Houston right now, he was the judge in Brownsville at the time, and I I had been down there, and he had about to have one of his law clerks leave, who had never seen a civil lawsuit because in Brownsville, basically all you do are you do cases involving immigration or drug cases. Well, so anyway, so I went down and I asked him if he'd like to do it, and we got permission from the judges in Corpus. It was the largest uh, uh, fraudulent conveyance case ever. It was in the billions of dollars, and even with that, they were able to essentially by buying the company, they basically didn't have to pay that judgment.
Wow. Wow. It must have been gratifying when you were able to sign the confirmation order in Asarco.
Right. Yeah, I don't know that I ever signed a confirmation order that paid 100 cents on the dollar and interest to all of the creditors. That
Yeah, that's
was just
remarkable.
amazing.
Was there ever, besides Asarco, was there ever another case that really tested you that, or the participants in a case that really changed how you saw justice?
Well, I think my favorite case was a case out of Laredo, where a gentleman who was fairly wealthy owned a subdivision outside of Laredo, in which there were low income families would buy a tract of land, and then they might put like a lean-to up, and they might go out there and do barbecues, and eventually they'd build a house there, and they would be satisfied. Well, all of those sales of land were done by a contract of sale, not by mortgages or anything of that sort. And uh, the the party the owner of this party had huge liabilities to the state for mistakes on uh, there was trash that had just been set up there and they'd never properly taken care of that. There were all sorts of environmental problems. There was problems with uh, the systems for waste and things of that sort. And when I looked at it, I realized that the price that they owed covered more than the value of the property. And so I suggested that there could be a plan whereby the property would be separated, and that that there would we were able to get the state to throw in some grants to clean up the property there and clean up the uh, the problems with that, and then we were able to convert all of those from uh, from contracts of sale to a mortgage with a reasonable interest rate.
Right.
And, you know, it all got confirmed, and all of those parties, they all spoke no English, but uh, Judge Leal would from Houston came down for one day for a hearing on the disclosure statement, and he's in Spanish told them, as I discussed it, he told all of those what was being done. I thought it was important that everybody involved in that, since they were all going to have a vote, needed to understand exactly what was being done and how fortunate they were going to be when they came through with that. But that it was confirmed, and to me, it's the probably the best use of the bankruptcy code uh, that I could imagine.
That's pretty neat. So, you've seen good lawyers, you've worked with some of the best, and you've seen some not good lawyers. During your time on the bench, what were your pet peeves?
Well, I pretty much told everybody ahead of time. I don't like uh, discovery disputes, and I don't like fee disputes. So, I basically told them ahead of time. I mean, I heard them, but I felt like they ought to solve those, and pretty much those were my peeves.
We've been known, as a user-friendly judge. I think everybody always appreciated your even keel. How important is that in how important is that tone in both presiding over court and in the administration of justice? I mean, we've all, heard stories about various judges in various districts who are, you know, terrors to be in front of or not. Um,
Yeah.
what's your take on that, Judge?
Well, I I just happen to have a pleasant disposition, and it doesn't bother me. I mean, I don't I don't really get upset when people say things, although they sometimes amuse me. I know I didn't have a lawyer that did this, but I had a pro se litigant one time that I mean, he tried all kinds of things. And I remember one hearing he was there, and he was talking and he was explaining, and he would say, you are the worst judge I've ever heard of. You did this and the other, blah, and he probably there were some cuss words involved, and but then he ended with all due respect, and I kind of chuckled, but anyway, that was that was unusual litigant, but.
Well, if you had to give some advice, if when you look back on your career, both off the bench, through the military, um, on the bench, what advice would you give to the next generation of judges stepping into, the very, very high stakes environment that we are in Chapter 11 and in bankruptcy these days?
Uh, well, I happen to have a daughter who now is a lawyer with a firm in Houston, doing bankruptcy, and I've given her this advice, and I believe this is good advice for everyone. I think you need to know the judge, you need to know his staff or her staff, you need to know the clerk of the court, you need to know all of the rules, and you need to follow those. Those are important. Now, perhaps there are some judges where rules are not as important, but most judges the rules are very important, and so I think you need to know the court and know how to practice in that court. That's probably the best thing I could tell you.
I appreciate that. Thank you. And finally, as we wrap up, are you still playing with Still Crazy?
Still playing with Still Crazy after all these years. That started as a band that would play at the UT seminar for the luncheon. And we would rewrite tunes. I would rewrite tunes like You've Lost That Lending Feeling. Why don't we get drunk and sue? We would rewrite tunes about that and rock and roll tunes primarily, and play them for them. And we did it for several years. Eventually, I started. We actually had learned quite a few. The band I had learned quite a few rock and roll tunes, and we just became a pretty good cover band because we were able to just play those tunes. But
Oh, that's
eventually, I think you can only rewrite so many tunes about bankruptcy, and so
I think
I
that's right.
ultimately ran out of tunes to do that. So we don't go there anymore. But the band still plays, and we play charitable events only. There are lawyers in there. It was there when I was a judge. Obviously, I couldn't make money with another lawyer. That would be a violation of ethics. I wouldn't do that. But ever since then, we still only play. We never play for money. We only play for charities. That way, we can do some good for the community.
Well, Judge Schmidt, thank you so much for being with us today, for your service in the military and for your service on the bench. And if I don't see you before, I'll see you in Austin at the UT Westbrook Conference in November.
Well, thank you for having me. I enjoyed it. There's no question about it.
Thanks, Judge. We'll see you.